This short video concerns the issue of equitable distribution in Florida divorce actions. Equitable distribution is the general legal term given to the various rules and concepts which govern the division of a family's assets and liabilities or net worth during a divorce. The equitable distribution analysis begins with the proposition that a family's net worth should be equally divided between the divorcing spouses. However, this is only an initial presumption. Frequently, the end result is not an equal division. Some assets and liabilities may be awarded or assigned solely to one spouse and not the other. These items are usually referred to as non-marital assets and non-marital liabilities. Florida Statute Chapter 61 is where the Equitable Distribution Statute is found. Florida case law further develops and refines this law. An in-depth analysis of the law of equitable distribution is well beyond the scope of this video. It is usually very fact-intensive and is often the subject of intense courtroom and mediation debate. The general concept requires that a judge separate marital assets and liabilities from non-marital assets and liabilities. The value of marital assets and liabilities is then usually equally divided, while non-marital assets and liabilities are usually awarded to the spouse who has a special interest or connection in or to the asset or liability. Each case involves a different analysis. Equitable distribution for a 2-year marriage may be very different than for a 20-year marriage. The existence of solely owned pre-marital assets or liabilities and the existence of inheritances may also make a big difference in the equitable distribution analysis. As a very general statement, non-marital assets and liabilities typically, but not always, fall under one of two general fact patterns. First, when an item was owned or owed by only one spouse prior to the marriage and was never given or assigned to the second spouse, nor combined with other marital items, and secondly, when the item was gifted to or inherited by only one spouse and was never given or assigned to the second spouse, nor commingled with other marital items. The analysis does not end here. Each spouse then retains the right to argue that they should be entitled to more than 1/2 of the marital net worth under the general concept that the facts of the case warrant an unequal distribution of marital net worth. These arguments are typically fact-specific, equity-based arguments, which are well beyond the scope of this short video. The best way to receive the most specific and accurate answers to your questions regarding equitable distribution is to seek professional legal advice from an attorney that is well versed in Florida family law. Any such case analysis should also cover other potentially related divorce issues such as alimony, child support, time sharing with children, and attorney's fees. Often these issues are not mutually exclusive, and a given outcome for one of these issues affects the outcome of the others. I hope that you have found this short video helpful. This website, tampadivorcenow.com, if you are not currently visiting the site, contains several other written statements and videos about the most common areas of family law in Florida. They are all logically and concisely written to maximize the flow of useful information to you as quickly and efficiently as possible. Feel free to navigate them as you feel the need. I am David Anton, a third-generation Tampa attorney that has predominantly practiced family law in the Tampa Bay area for nearly 30 years. It's not just my job or even my career, it is my calling. For a quality initial consultation that you and perhaps your children both need and deserve, please feel free to call my office at 813-443-5249. I wish you the best of luck with your family law issues.